So Celia is a Senior Community Relations Officer for Queensland Human Rights Commission. Celia has had a diverse career that has included the development, implementation and management of projects, programs, services in the community, health and education sectors, that's local and state government. She's held roles of managers, project officers, policy writers, educator, researcher, conference organiser and training consultant. Celia has worked in primary and tertiary health, education, mental health, disability, drug and alcohol, youth, community services. She has spent over 10 years in Victoria working with multicultural communities. Celia has conducted training, lectures and presentations for state government councils and the health sector and community services providers, police, educational institutions. Celia's commitment to social justice and the valuing of diversity and inclusive practices has been a consistent theme throughout her work. So we're very fortunate to have her here. I am going to just stop sharing and get your PowerPoint up, Celia, so we can get started.
Okay, so hi everyone. I'm just going to spend some short time taking you through the Queensland Human Rights Act so we can move on. Right, thank you. I would like to start by acknowledging the traditional owners of the land we are all on, wherever we are today, and pay my respects to elders past, present and emerging, and to all First Nations people. So I'm just quickly going to take you through the functions of the Queensland Human Rights Commission, and then we'll have a look at modern human rights law, because that's where the human rights law in Queensland comes from. We'll have a look at the responsibilities of public entities, courts and tribunals and Parliament under the Act, and talk about what it means to give proper consideration to human rights when we make decisions, and to act and make decisions in a way that is compatible with human rights, which is our obligation under the Act if we're a public entity. And I'll also quickly explain the human rights complaints process for you. So in terms of the Commission, the best way to describe us really is there's three parts to us. There's the section that I belong to, which is all about community engagement and training and all of the information that gets put up on our website. We also have a team that of lawyers, and they're our legal policy and research team. And that team, deals with any questions of law around the Anti-Discrimination Act or the Human Rights Act. And they also, do submissions to royal commissions, etc. And then, of course, we have our conciliators who conciliate complaints under both the Human Rights Act and the Anti-Discrimination Act. We also have a couple of other obligations under the Human Rights Act, and that is to assist the Attorney-General in the review of the Act, and the Act will be reviewed every 4 years. And also the Commission will intervene in court and tribunal proceedings where there needs to be further discussion around the interpretation of the Act, or there's some concern around the interpretation or the application of the Act. So thank you. So let's have a look at where it all come from. So the Universal Declaration of Human Rights was adopted in 1948, and it really came out of the atrocities of World War I and World War II. And it was very much, there was a sense internationally, I think, where countries wanted somewhere they could come together to try and maintain world peace and to be able to deal with the social and economic and cultural problems that happen. And so the League of Nations became the United Nations, and the Universal Declaration was adopted. So the Universal Declaration was worked on by 8 nations, and Australia was one of those 8. So we had a delegation that went to San Francisco to work on the declaration, and Dr. Herbert Everett was the head of our delegation, and he went on to become the president of the General Assembly of the UN when the declaration was adopted. But we also have a prominent feminist activist, Jessie Street, who was part of our delegation. And Jessie and the women that she met while they were working on the declaration, they did very important work. So the first draft of the declaration was had a lot of gendered language. And so it said all men and brothers are born free and equal in dignity and rights, for example. And the women campaigned and had that gendered language removed so that it says all human beings are born free and equal in dignity and rights. So very important work. And, you know, if we play that forward in our head to today, I think the rights of women internationally would look quite different if that work hadn't happened. Sorry, Sam, can we go back to the previous slide now? Thank you. All right, so the Universal Declaration, I see it as a very aspirational document. It's an amazing piece of work. It was the first time that as humans we actually laid down what we believed were the rights that needed to be respected for everyone, for all of us to be able to live a dignified life. So after the declaration was adopted then in 1966, we get the first two covenants under the declaration, and these covenants are called treaties. They are treaties. So we get the International Covenant on Civil and Political Rights, the ICCPR, and the International Covenant on Economic, Social and Cultural Rights. And then you can see under the two covenants, then there's a whole lot of other treaties. For example, the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, the Convention Against Torture and Other Cruel, Inhuman and Degrading Treatment or Punishment, the Convention on the Rights of Child, the Convention on the Rights of People with Disabilities. I just want to point out on this slide that the Indigenous peoples is not a treaty, it is a declaration. And so it's not a legally binding. A declaration isn't legally binding like a treaty. So, and also, while Australia has said they support the Indigenous Peoples Declaration, we haven't actually signed up to it. So we haven't put our signature to it. So these international laws, what Australia does at an international level, at the UN level, is we ratify these treaties. So we ratify these covenants and conventions. And when we ratify them, what we're doing is we're legally obligating ourselves to them. Okay, so we're saying we agree, we sign up to this, but it doesn't become law for us until it's in our own domestic law. And this is how it translates into our domestic law. So in Queensland here, we have the Anti-Discrimination Act. You can see the 5 acts that work at a federal level, the act that forms the Australian Human Rights Commission, and then the Sex, Racial, Disability and Age Discrimination Acts. And, of course, all states in Australia have their own version of an Anti-Discrimination Act. So I'd just like to pause here quickly to tell you about a true case scenario that will help you understand the difference between a Human Rights Act and an Anti-Discrimination Act. So when the Human Rights Act was being lobbied for in Queensland, and it was very much a grassroots movement that brought about the Human Rights Act. It didn't come from the top down, it came from the bottom up. And people were saying, you know, we really want to see Queensland with a Human Rights Act. And, of course, at the same time, there was some opposition. And the people opposing it, they were saying, look, we don't need to make things complicated. We have an Anti-Discrimination Act and, therefore, people are protected. So we already have protections in place. But if you know anything about the Anti-Discrimination Act, you will know that to be protected under the Act, you have to have one of 16 attributes. So that might be age or race or religion or sexuality or gender identity or parental status. So 16 attributes. And then the discrimination or the human rights limitation or breach needs to have happened in one of 9 areas. So we've got 16 attributes and 9 areas. So the true case example I'm going to tell you about comes from the UK. So the UK has the same model of human rights as Queensland does, and that's called a dialogue model. So a woman in the UK was escaping family violence. She has 2 daughters and they were all unsafe. So she fled her domestic situation and tried to make it so that her partner couldn't find them, couldn't track them down. Anyway, sadly for her, that didn't work out, and he did find them. And so once again, they were all unsafe. And once again, she needed to pack up the children and flee again. So this happened a few times, and eventually she ended up being referred to the Department of Social Services in London. She ended up in London. And when she went in to see them, she probably went in thinking they were going to help her. They assessed the situation, and the conclusion they come to, or the decision they came to, was that she was a really bad mother and that the children needed to be removed from her care and put into out-of-home care, and they didn't feel compelled to help her any further. Luckily for her, she had been to the British Institute of Human Rights Advocacy training, so she knew about her human rights, and she probably knew some good advocates. And they challenged the department to give proper consideration to her human rights in regard to that decision, and called for a review of that decision based on what is our Section 26, the protection of families and children. And the outcome of that review is the department completely backed away from any notion that they would remove the children from her care, and the department also agreed that they needed to help her find appropriate housing. If there had only been an Anti-Discrimination Act, she would not have met the threshold to have a complaint. All right, so there's no attribute under the Anti-Discrimination Act that would protect someone who is in a situation of family violence. So human rights belong to all of us by virtue of the fact that we are human, and they're not limited like the Anti-Discrimination Act is to a list of characteristics. All right, so this wording comes directly from the Act. And the Act is actually quite easy to read if you want to jump on Google and Google a copy of it. So the objectives of the Act are to protect and promote human rights, to build a culture in the Queensland public sector that respects and promotes human rights, and to promote a dialogue about human rights. So it's very much about the inherent dignity and worth of all human beings. All right, so we have 23 sections of our Act that actually protect rights under the Act. 21 come from the ICCPR, the civil and political rights, and 2 of them come from the Covenant on Economic, Social and Cultural Rights. So sections 15 to 35 from the ICCPR, and then Queensland's unique in that it has the right to education, which is section 36, and the right to health services, which is section 37. So there are only 2 other states in Australia that have human rights legislation, and they are the ACT and Victoria. Victoria has neither the right to education or the right to health services in their Charter of Human Rights. And the ACT does have the right to education in their legislation, but not in the same way that Queensland does. So currently, Queensland is seen to be to have the most progressive Human Rights Act in the country. Next slide. So here's a list. So people often ask me what comes before Section 15 of the Act. So when you have a look at the Act, Sections 1 to 14 are all the preamble and the role of the Commission and, you know, definitions, legal definitions. So the actual rights start at Section 15. The right to recognition and equality before the law. We call that right our discrimination right. So whenever we get a sense that something is discriminatory, you know, something going on in the situation is discriminatory, a human rights advocate would definitely be looking at Section 15. Just to let you know, like Section 16, the right to life, does not include anything to do with terminations of pregnancy. So it doesn't impact that, and nor does it impact the right to end life. So euthanasia legislation, end of life legislation. Freedom from forced work is something that we've not seen, and hopefully we don't see in Australia. The only case I've come across of freedom of forced work was a group of Vietnamese children in New Zealand. So that's very much about being coerced to work. Section 28 is very important to us, the cultural rights specifically for Aboriginal and Torres Strait Islander peoples. So cultural rights are there in Section 27 generally, but our Act acknowledges the very special place of First Nations people. All right, we can go on. So this is the dialogue model of human rights. This is what it looks like. So there's two models of human rights. There's the dialogue model and the constitutional model. So you actually might be more familiar with the constitutional model because it's the American model. And if you watch American TV, you will often hear them talking about their constitutional rights. The difference being with a dialogue model, and a dialogue model is you can think the UK, New Zealand, Victoria, the ACT, Queensland. In a dialogue model, Parliament is the seat of power. So all 23 sections of our Act can be limited, and they can be limited by passing legislation, but only to the extent that is reasonable and justifiable in a free and democratic society. So our Human Rights Act is a normal act of Parliament. It's not embedded in our Constitution. In a constitutional model, the courts are the seat of power. Okay, so you can think Canada, the United States and South Africa. So in those countries, courts can overturn legislation when it comes to human rights. Okay, so the obligation under the Act for Parliament, so from the 1st of January 2020, if a minister in Queensland wants to introduce a new bill into Parliament, they must accompany that by a statement with a statement of compatibility to the Human Rights Act. So if they want to limit human rights, that statement of compatibility needs to spell out why that is reasonable and justifiable. So in the COVID world that we're living in, we have had our freedom of movement limited by legislation that the government has introduced. You know, we've been locked down at home. We've been not able to cross the border at different times with, you know, masks have been mandatory. All those things have human rights limitations involved. But in balancing whether or not that's reasonable and justifiable, of course, we need to look at the fact that the virus can kill people, and therefore the government needs to protect the right to life, Section 16 of the Act. And so we would all agree that it's reasonable and justifiable that we limit our freedom of movement to protect the health of the community. All right, so courts and tribunals, their obligation is to try and interpret laws in a way that's compatible to human rights, certainly to the extent that is possible or most compatible. They are also public entities and obligated under the Act when they're performing functions of an administrative nature. And that's such things as acting as a registry, waivering fees, reviewing a decision, appointing a guardian. So they're all administrative nature, of administrative nature. So QCAT, the Queensland Civil and Administrative Tribunal, and things like the Mental Health Review Tribunal, they're working through a process to understand when they are a public entity and when they aren't. So under the Act, there are three types of public entity. There are core public entities, and they're public entities at all times, regardless of their functions. There are functional public entities. So they're only considered a public entity when they're performing a function of a public nature. So we can ask a couple of questions to try and think through whether something's a public entity. We can ask, are they performing a function government would normally perform? And are they being funded by government to do so? And then there's opt-in entities. So let me give you some examples. So core public entities, all ministers, all Queensland ministers, all state government departments, all state government employees, all locally elected councillors, all local government organisations and local government employees, our police and all of our emergency services, our Department of Education, all of our public education, including public universities, TAFE, and public schools. Obviously, our public health system, so not private schools, not private health, all public entities. Department of Transport and Transport. Functional public entities, you can think something like a private prison, so funded by the Department of Corrections to run a prison, community housing provider funded by the Department of Housing to provide housing for people in Queensland, a small private bus company might be funded by the Department of Transport to provide a bus service in a small town in Queensland. Opt-in entities, when you look at the NGO sector, they often have funding from multiple sources, including federal and state and philanthropic, etc. This Act creates real confusion for NGOs potentially and their staff. So it might be that some staff in the organisation, because they're funded by the Queensland government, are obligated to the Act, whereas other staff working in different programs are not. So NGOs have said to me that all gets very confusing and they're just deciding they're just going to opt in their whole organisations to deal with that level of confusion. All right, so under the Act, we have two responsibilities and they're very interlinked. So one is to give proper consideration to human rights when making decisions, and the other is to act and make decisions in a way that is compatible with human rights. So this is Section 58 of the Act, and Section 58 of the Act is the only section of the Act that we can breach. So we don't talk about breaching rights, we talk about limiting them or unreasonably limiting them or protecting them. But in terms of proper consideration and compatibility as a public entity, that is part of the Act we can breach. Next slide. All right, so the purpose of proper consideration, and think back to the mum in the UK and her situation, the purpose is to improve our decision making. So to ensure if a public entity wants to limit a human right or restrict a right, that there is reflection and deliberation about whether the act or decision strikes the right balance between the individual's rights and broader considerations. So the human rights space is always a balancing act. Sometimes we're needing to balance one group's rights against another. So if you think about the freedom of expression, yes, we have freedom of expression under the Act, but you can't use freedom of expression to incite hatred towards groups of people you may not like. All right, so that's, an example of that balancing. So this is from Justice Osborne from the Victoria Supreme Court. And Justice Osborne made very clear that you don't need to be a lawyer to give proper consideration to human rights. It doesn't need to be a sophisticated legal exercise. So it is possible we have a flow chart that is called assessing compatibility, and it is quite easy, really. It's not that complicated to use an assessing compatibility flow chart to just reflect on the decision and to think about which sections of the Act might be involved in a decision that we make. So compatibility with human rights, which is in Section 8 of the Act, is the other, it's a unifying concept throughout the Act. So if we're not limiting a human right, if we're going to make a decision and that decision does not limit a human right in any way, it is automatically compatible with human rights. Oh, sorry, can we go back? Previous. Yep, and previous. Thank you. But if we are going to limit a human right, so we make a decision that is going to limit a human right, we can do that, but we have to be able to say why that is reasonable and justifiable in a free and democratic society based on human dignity, equality, and freedom. So we must, like I said, apply some thinking and examine the decision. So this is how we assess compatibility with human rights. So to decide if a limitation is reasonably and demonstrably justifiable, we have to consider the objective of the decision, like what are we trying to achieve by making the decision or taking the action. We need to think about, of those 23 sections of the Act that list out the rights, have we engaged any of those sections of the Act? And if human rights are being limited by the decision, we have to know what is the purpose of our limitation, like what are we trying to achieve by the limitation. We also need to be clear about, whether or not the benefits outweigh the harm caused by the limitation, and also if there is a less restrictive way to achieve the purpose. So I'm just going to give you a couple of examples. So my first example is going to be incompatible with human rights. And this is a true situation that happened in Victoria. So it was about a young woman. She's 15 years old when this happens. And what she did was she travelled on the train without a ticket. And so the security guards working at, I think it happened at Flinders Street Station in Melbourne, they saw her scaling the barrier, because she couldn't open the thing because she didn't have the ticket. So they've realised that she's travelled without a ticket. So, and they've decided that they're going to intervene and, arrest her or get her arrested for travelling without a ticket. Issue her a fine. So they start to go towards her, and I'm not quite sure what happened, except that what the CCTV and witness accounts showed is that one of those security guards ended up spear tackling her to the ground, and they held her down, face down, for 8 minutes and 3 officers were holding her down. So we ask a question in this situation, is it lawful? Well, yes, this is lawful in that these security people would have had the lawful authority to act in terms of restraining her. But if we start to ask questions like, what is the purpose of the limitation? Because they limited her right to freedom of movement and they limited her right to protection from torture, inhuman and degrading treatment. So the purpose of the limitation was to restrain her, but that wasn't a rational act. So did the benefits outweigh the harm? Well, no. I mean, she was potentially quite humiliated and potentially injured in that situation. And the court looked at it and said, well, would there be a less restrictive way to achieve the purpose, which was to keep her in a place while the police arrived? Well, when they looked at it, they said, well, of course there was. They didn't need 3 people to basically sit on her to hold her down. So that was seen as incompatible with human rights, and the Victorian Ombudsman had a lot to say about that situation. The second example, which is compatible with human rights, is about a young woman who was living in a residential care unit, and she began to present as an immediate risk of harm to herself and others, and the Department of Health and Human Services needed to consider locking her door to keep her safe. So they recognised that their action would limit her right to liberty and security of the person and her freedom of movement. So they really applied some thinking to their situation. They got together, gathered a lot of evidence to demonstrate that locking her door would be in her best interests. They made sure that it was always a measure of last resort. They contacted the Commission for Children and Young People and invited independent oversight of the situation so that there was independent scrutiny. So even though they were limiting her human rights, it was judged that it was reasonable and justifiable because of the level of protection it provided her in that situation. Thank you. All right, so this is the complaints process. If you know anything about the anti-discrimination complaints process, you might know that if people have a complaint under the ADA, they can come straight to the Commission. So they don't need to engage in any other internal process. But that's not so with the Human Rights Act. So with the Human Rights Act, if you have a human rights complaint, you need to make that complaint to the public entity first. All right. And the public entity then gets 45 business days to engage with the complainant and to start working towards resolving the situation with the complainant. It doesn't need to be fully resolved within the 45 business days, but certainly from the Commission, from our point of view, what we would be looking for is that there is very open and genuine engagement. Remember, this is a dialogue model, and, efforts are really being made to resolve the problem. If that doesn't happen, so either if the public entity doesn't respond, and we certainly did have public entities saying to us in the early days, we can't possibly respond in that time, we need, 5 months to respond to a complaint. Well, we don't really see that's right. And under the Act, they do need to respond in the 45 days. But if they don't respond or the response is really inadequate and there's no genuine engagement, then the complaint can come to us. So the complaint has to come to us in writing. Our conciliators will assess that complaint and decide whether or not we can accept it. Complaints need to be about things that have happened within the last 12 months. So you can't come with either complaint mechanism with something that's happened years ago. If we accept the complaint, then the conciliators can call a conciliation conference and bring all the parties together. And the conciliators can make some recommendations around what they believe needs to happen in the situation to make sure that human rights are being protected. We can't force public entities to do anything. And also, there is no financial compensation for hurt and damages under the Human Rights Act like there is under the ADA. So what the Commission can do, though, what we can do, though, is if we are dealing with public entities who consistently do not protect and promote human rights, we certainly have the ability to publicly name and shame them. Thank you. These are the typical kinds of remedies that people can ask for with a human rights complaint. So an apology to acknowledge hurt and distress, a change to or reversal of a decision or action, or a change to the person's circumstances, like they might get moved to a different facility or they might go to a different school or something like that, an agreement to provide a service or implement policies and practices, or an agreement to review or change policies and procedures. So the Victorian Ombudsman, you know, they were really looking for the Department of Transport in Victoria to change their policies and procedures around, you know, restraint of people when it came to the young woman. An agreement that staff undertake training. Sometimes the issues, human rights issues that arise come out of a lack of understanding of human rights on the part of staff. And people can ask for compensation for costs they've incurred. So not for damages and compensation for damages, but, you know, for example, the cost of having to move school, or the fact that you might needed to have sought some mental health support and what that cost you. Okay, we can go to the next slide. We refer complaints on where we believe that they belong somewhere else. If a complaint is actually a decision that can be reviewed in a tribunal or court, we would suggest that that happens. We can also send complaints to the Ombudsman, the Health Ombudsman, the NDIS Commission, the Crime and Corruption Commission, for example. Yep. We might do what's called a piggyback action. So if a complaint comes in and the human rights breach or unreasonable limitation involves one of those 16 attributes protected under the ADA, we might say to the complainant, let's run the complaint under the ADA, and then we will piggyback on to that complaint all of the human rights considerations that are part of that complaint. And that's certainly what lawyers do in courts and tribunals. We've just released our first human rights annual report, so the report on the first year of the Act. If you would like to look at it, you can see it on our website. And just so you know that Queensland state government departments report to us under the Financial Accountability Act. You will find lots and lots of information on our website with regards to human rights. There is a public entities toolkit on the website, which is a very useful document. It gives you a lot of the information that I've given today, but really helps also with understanding how to build a human rights culture within your organisation. And that's it.